I'm calling to order this hearing. This is a public hearing of the Committee of the Whole of the Council of the District of Columbia. I'm Phil Mendelson, Chairman of the Council and Chair of the Committee of the Whole. Today is Wednesday, November 2nd, 2022. The time is 12:38 in the afternoon, and this hearing is being conducted virtually. It's being broadcast live on the chairman's website, www.chairmanmendelson.com/live. It's also available on the council's website. I'm not sure if it's live, www.dccouncil.gov. And it will be recorded or is being recorded and will be available on the council's website. Again, www.dccouncil.gov. The subject of this hearing is Bill 24-989, entitled the Educator Background Check Streamlining Amendment Act of 2022. This legislation was introduced on September 16th of this year by Councilmember Christina Henderson, joined by Councilmembers Nadeau, Bonds, Robert White, and myself. The stated purpose of this legislation is to revise the suitability screening process for individuals applying to work as a teacher or volunteer in schools and educational programs in the District of Columbia. While a typical background check should take around 21 days, teachers, prospective volunteers, community-based organizations, parents, and school leaders are reporting a turnaround time of upwards of 3 months or more. This has negatively affected schools and programs and their ability to recruit and hire critical staff like substitute teachers and tutors. It also has affected the ability of local education agencies to recruit volunteers. Bill 24-989 seeks to address this. I will add that the Police Reform Commission, which the council established in 2020, made a number of recommendations that might seem a little incongruous here, but one of their recommendations was to facilitate the deployment of violence interrupters in schools. The council should amend the law to remove nonviolent felony convictions from the list of convictions that disqualify volunteers from working in DC public schools or public charter schools. That's some relevance here. I could say more, but we have a number of witnesses and I'll let them speak. We've been joined by my colleague, Councilmember Christina Henderson. Do you have an opening statement?
I do, Mr. Chairman.
Please.
Thank you, Mr. Chairman, for holding this hearing. I think it's safe to say that every member of the council has been hearing from educators, parents, out-of-school time program coordinators, volunteers, and school leaders for the past couple of years about the delays in terms of DCPS processing applications. These allegations, well, I'll call them anecdotes, were especially concerning as students prepared to return for in-person instruction. The pandemic had impacts on many of the facets of our education system. Burnt out teachers left the profession, learning loss required intensive interventions, and that addressing learning loss required adequate staffing of out-of-school time or additional programming. When Chancellor Farabee mentioned during a Committee of the Whole hearing last fall that the delays were due to a past council action, I reached out to our education agencies to learn more and to see if they wanted to partner on a legislative solution to their challenges. DCPS quickly wrote back and that the Student Safety Omnibus Amendment Act of 2018 had added steps to the agency's suitability screening processes, the most time-consuming of which was the requirement that the DCPS check every child abuse and neglect registry in the United States. DME, that was for a potential applicant. The DME followed up with me in March of this year with additional legislative suggestions, and my staff worked closely with those agencies to draft this legislation, including CFSA. We also learned more about the child abuse and neglect registries during the drafting process, and that the Child and Family Services Agency contributed their expertise to devise the language amending the district's expungement statute concerning our child protection register. This bill would make corrections to a few pieces of the suitability screening process for prospective educators and volunteers. The bill will appropriately scale the reach of the child abuse and neglect checks to states in which the applicant has lived or worked, rather than requiring a review of every child abuse and neglect registry in every state. It also removes the requirement that LEAs determine if an applicant is subject of an inconclusive report of child abuse in states in which they've lived or worked. The bill also revises the CPR expungement statute by tiering offenses based on the outcome of the report and any subsequent findings. And finally, it would require a review of the National Sex Offender Registry during the candidate suitability screening process. Excuse me. There's a lot more that the bill will do, but this opening statement has gone on far too long. And so, as you said, Mr. Chairman, we have a lot of witnesses. I look forward to the conversation today. Thank you.
Thank you, Councilmember. I thought your statement was fine, and I don't think it went on too long. But let me call the non-government witnesses. All will be let in, and we'll hear from each of you, and then we may have some questions for you. Riley Danilko is listed as a policy analyst. Sarah Warren, David Trudeau, who's with the Washington Urban Debate League. Aaron Pitts, who's Managing Director of Employee Policy at KIP DC. Tammy Burasinga-Cote, who's Supervising Policy Attorney at DC Children's Law Center. Carlene Reed, who's the Ward 8 representative on the DC State Board of Education. Marie Cohen, who's author of the Child Welfare Monitor blog. Audrey Walker, who's Director of Youth Services for Jubilee Housing. Curtis Leach, who's with Kid Power, Inc. Victoria Williams, who's Education Coordinator with DC Strings Workshop. Sharn Booth Ruffin, who's with PAVE as a citywide and Ward 8 rep. Joellen Ambrose, who's a policy intern with Jubilee Housing. And Kaylin Keller, who's staff attorney at DC Kin Care Alliance. We'll begin with Ms. Danilko. I probably should say this. The clock will be set for 4 minutes. If you're in gallery view, you should be able to see the clock. If you're lucky, sometimes staff forgets to start the clock, and then you can go on and on and on. But otherwise, please keep your remarks to 4 minutes. Ms. Danilko, you're first. Good morning.
Good morning, Chairman Mendelson, and good morning to Councilmember Henderson. Thanks for the opportunity to address the DC Council today. I'm Riley Danilko, a policy analyst at DC Action, home of the DC Out of School Time Coalition, and I'm testifying today in support of the Educator Background Check Streamlining Amendment Act and to share additional recommendations for improving the background check process. I'd like to thank Councilmember Henderson for introducing this legislation, along with Chairman Mendelson and Councilmembers Bonds, Nadeau, and Robert White for their support. For more than 2 years, the background check process, as sanctioned by the School Safety Omnibus Amendment Act of 2018, has been a source of significant OST program delays, hiring challenges, and most importantly, a barrier for after-school and summer programs' ability to meet the needs of the young people they serve, particularly for those who partner with DCPS to provide programming. While we understand and appreciate the Council's intentions in strengthening protections for students in school and OST settings, we believe the implementation of the SSOAA has been flawed and requires immediate improvements, including those proposed in this legislation. OST Coalition members have shared their experiences as direct results of the challenges with the clearance process, including examples of programs that had to delay programming or pull out of DCPS entirely, and programs that had multiple employees withdraw their applications because of the delays. Please see my written testimony for these examples. I also want to encourage the Council to remove the CPR requirement from the SSOAA for clearing school staff and contractors. As council members wrote in the statement of introduction for this bill, the CTR check is not a useful tool for judging a person's ability to work with youth, and other elements of the clearance process adequately capture information about applicant suitability. We also urge the council to call on the leaders of education agencies to take additional steps to improve the clearance processing time. While the legislation at hand might speed up some of the individual pieces of the process, it does not address the fundamental flaws of the process, which is that it is decentralized. Not only is the application itself administratively burdensome, but it's not clear that DCPS in particular has any way of tracking the progress of individual applicants easily. It is next to impossible for candidates to get an update on the status of their application because the various pieces are handled by a combination of different agencies and external vendors, with apparently no central system to track these pieces. This puts the onus on applicants or the nonprofits that hired them to spend time tracking down someone who can give them a status update on each individual component, which is especially difficult for community-based organizations with limited resources and staff. In addition, we know that in 2022, technology exists to give real-time feedback about missing required information on an online form. This must be implemented into the background clearance process so that human errors can be flagged and corrected within seconds, rather than an applicant having to wait weeks or months to be notified that they missed a section or a box on a form. Many organizations that work in school districts around the region, as well as in DC, have said that other jurisdictions have much faster turnaround times for staff and volunteers. DC should look to them as models or risk losing high-quality programming from organizations who might consider directing their resources toward a city, county, or school district where they know they can reach other young people in need of OSP. Thank you for your time and consideration. Happy to answer any questions.
Thank you, Ms. Danilko. Sarah Warren?
Mr. Chairman?
Yes.
Sorry, I saw in the chat, Representative Reed has a conflict at 1:10, and I apologize. I know we started a little bit late. I was just curious whether or not she might be able to go next, just so we can get her testimony on the record.
Give me a second here. Yeah, that would be fine.
Thank you.
Ms. Reed?
Yes, thank you, Chairman Mendelson, Councilmember Henderson, and members of the Committee of the Whole. I am Dr. Carleen Reed, the Ward 8 member of the DC State Board of Education. This testimony is related to the Education Background Check Streamlining Amendment. I'm testifying as the Ward 8 member, and my summary should not be considered as a reflection of the views of the board. The DC State Board of Education has participated in some activities related to a few topics mentioned in the proposed bill, and I just wanted to highlight some of those, or some of my takeaways from some of the information that we've heard from community members. Recently, the DC State Board of Education hosted a panel on violence in school communities. A couple of participants on that panel were members of an organization that provide violence interruption services in schools. They mentioned that the backlog and background checks creates a barrier to their recruiting and being able to deploy workers to sites, which causes understaffing. I encourage the Committee of the Whole to consider how this bill can reduce the barriers for violence interrupters to get background checks completed for them to do their work in school settings. As you know, many of the individuals who do the work have previous histories with the justice system, not all, but I believe it gives them a unique skill set to do their work in a way that many of us cannot, and could be very meaningful and impactful to students. I ask the council to consider waiving any previous charges that were not directly connected to the well-being and safety of children, and also consider if individuals are connected to violence interruption programs, how can specifically they be, considered in a different way. Second, the DC State Board of Education also hosted a panel on sexual assault in schools, and I concur with the bill's proposal to include the National Sex Offender Registry data. We've learned that, particularly through that panel, oftentimes there may be individuals who may move from state to state, or from LEA to LEA, and sometimes that information goes missing. So as much as possible, include that information into these background checks. I will send you a copy of this statement once I proofread it. And thank you, Councilmember Henderson, for allowing me to move up.
Thank you, Dr. Reed. And I was going to ask for the statement, so I appreciate that. Since you have to leave, let me just ask if any of the council members present have questions for you. Councilmember Henderson,
I don't, Mr. Chairman.
and we've been joined by Councilmember Nadeau.
Thank you so much for your testimony.
All right, so thank you for your testimony, and I will look at it more closely because you're making some suggestions that may help refine the bill. Thank you. So you're off the hook. I guess you can disappear. Everybody else has to stick around. That's why it's the Great Ward 8. Sarah Warren, I think, is not here. David Trudeau. Aaron Pitts. Ms. Pitts,
I'm here.
please proceed.
Okay. Good afternoon, Chairman Mendelson and members of the council. My name is Erin Pitts, and I'm the Managing Director of Employee Policy for KIPP DC. In this role, I help to interpret employment laws such as the School Safety Omnibus Amendment Act of 2018, which I will call SOA. At KIPP DC, we know that our most important responsibility is to keep our 7,000 students safe. So we believe SOA was right to require LEAs to have policies on abuse prevention and to train not only staff, but also parents and students on abuse prevention. Further, we believe SOA was right to tighten pre-employment screening measures to some extent. At the same time, we are pleased the council, in proposing the Educator Background Check Streamlining Act, is taking a close look at the areas of SOA that have not worked so well. We support amending SOA in a way that strikes a better balance between being thorough and being expedient when performing suitability checks. We share the council's interest in expediting the process by which candidates are screened for work in schools. We understand that delays in filling staff vacancies have very real negative consequences for staff retention and student supervision. Simply put, staff vacancies present their own safety risks. As such, we support the council's proposal to narrow the look-back period used when conducting employment history checks, while also expanding suitability screening to include a check of the National Sex Offender Registry. That said, we are worried about the potential repeal of the requirement that LEAs contact a candidate's former employers to inquire about any possible child abuse. If that provision is removed, we fear that LEAs may miss red flags that can only be detected by consulting prior employers. We ask that this aspect of the proposed legislation be given additional consideration. Further, we encourage the council to consider the following amendments. First, allow LEAs to hire staff after they have completed the criminal history background check and the National Sex Offender Registry check. LEAs can then condition an employee's continued employment on passing the remaining checks. Second, expand the number of DCHR staff who provide suitability screening services to LEAs. Presently, DCHR provides these services to KIPP DC and 20 other LEAs. Since partnering with DCHR, KIPP DC has seen a dramatic reduction in the time it takes for us to receive background check results. We would like for more LEAs to experience this same benefit. Third, provide LEAs with free access to DCHR's suitability screening services. No LEA should have to choose between having the budget to hire a teacher and having the budget to screen that teacher. And finally, clarify to whom the background check requirements apply. SOA requires LEAs to conduct background checks on all employees and contractors that occupy, and I quote, a position that involves direct interaction with students. We have grappled with what this phrase means. Could this apply to individuals who perform HVAC repairs in schools? To individuals who briefly enter schools to deliver goods? Council could assist by amending SOA to clarify that only unsupervised contractors and/or individuals who spend a minimum amount of time in schools are subject to the suitability screening. In closing, passing the Educator Background Check Streamlining Act with the aforementioned changes will better ensure schools can screen staff in a thorough and expedient manner. We look forward to working with the council and administration to continue moving towards an efficient hiring process that centers the need for every student to be safe in every school. Thank you for your time.
Thank you, Ms. Pitts. That's very helpful. Kemi Versinga Coat.
Good afternoon, Chairman Mendelson and
Was
members
I
of the council.
close in pronouncing your name correctly?
Yes, you got it. Weerasinga Kote, but usually people really get stuck on the Weerasinga. So
Okay,
I
yeah,
appreciate it.
Councilmember Nadeau is looking disapproving of me, not you, of me.
You did you gave it your best shot, Chairman. Let's not use her time.
Good afternoon, Chairman Mendelson and members of the council. My name is Tammy Weerasinga Kote. I am the supervising policy attorney at Children's Law Center and a resident of the district with 2 children who attend DC Public School. I'm testifying today on behalf of Children's Law Center, which fights so every DC child can grow up with a stable family, good health, and a quality education. Thank you for the opportunity to testify today regarding the Educator Background Check Streamlining Amendment Act of 2022. Although this draft legislation is largely focused on streamlining the background check for teachers and volunteers in DC schools, this act also has important implications for child safety and the district's child protection register. Children's Law Center supports all schools having the staffing resources they need to fully meet the needs of the children they serve. We also feel strongly that any person entrusted with the responsibility and care of children in our schools should be screened for their child abuse history in the district and in any place where they have lived or worked. To this end, although we support the proposed legislation's goal of limiting the reach of these checks to states in which the applicant has lived or worked, we believe that these remaining checks are critical to maintaining child safety because these registries often contain information about serious instances of child abuse that will not show up in other parts of the background check. Further, we are concerned that the act proposes repealing all of DC Code 38-951.03A3. This subsection requires hiring local education agencies to review an applicant's employment history and contact former employers to ask whether the applicant has a history of abusing children or sexual misconduct. We do not believe the intent of this act is to eliminate any requirement to contact former employers, and therefore urge that this subsection remain as it is to ensure this important step is taken. Children's Law Center is strongly supportive of the proposed legislation's efforts to reform the Child Protection Register statute by creating a pathway for expungement. Currently, placement on the Child Protection Register is largely permanent, resulting in lifetime barriers to employment and family stability, both of which directly impact the well-being of children and families in the district. We share the committee's goal of creating a tiered structure that allows for expungement in some cases. This interest, however, must be balanced with adequate protections for child safety. To this end, we urge the committee to make 2 changes to the proposed legislation to strengthen it and ensure it conforms with the recommendations of the Children's Justice Act Task Force. First, we urge the committee to broaden the definition of serious physical injury for Tier 3 offenses to include the full scope of injuries included in the task force's recommendations. In its current form, the proposed legislation defines serious physical injury as a physical injury which creates substantial risk of death or which causes serious and protracted impairment of health or protracted loss or impairment of the function of any bodily organ. This definition is much narrower than the definition provided by the CJA Task Force recommendation, which includes specific types of injuries that, while not necessarily life-threatening, demonstrate intentional extreme violence against children, including burns, broken bones or fractures, suspicious head injuries, injuries of different ages which are indicative of a pattern of abuse, medical abuse, adult-sized human bites, and cases involving children who have been tortured, tied, or confined. Individuals with substantiated reports of such intentional extreme violence against children should remain flagged in the register, and we strongly urge this committee to ensure this legislation adopts the broader definition used in the CJA Task Force recommendation. Second, we ask the committee to ensure the legislation requires a petition-based process for expungement rather than an automatic date-triggered process. We believe the determination of whether and when expungement is appropriate should be done through a petition-based process that places responsibility on one or more persons to make an intentional and informed expungement decision that considers all available information. The exercise of careful judgment will be particularly important when determining whether a substantiated report falls under the category of serious physical injury and is therefore not eligible for expungement versus non-serious physical injury that can be expunged within 3 to 5 years. This is not only critical to ensuring good decision-making, it is also important to allow for due process so that individuals have the ability to challenge decisions to not allow expungement. To these ends, we urge the committee to ensure The proposed legislation includes a petition-based process for making expungement decisions. Thank you for the opportunity to testify today, and I welcome any questions you may have.
Thank you. Marie Cohen. Audrey Walker. Curtis Leach. Victoria Williams. Sharon Boone Ruffin. Joellen Ambrose. Kaylin Keller.
Good afternoon, Chairman Mendelson and members of the Committee of the Whole. My name is Kaylin Keller, and I'm a staff attorney with the DC KinCare Alliance. Our mission is to support the legal, financial, and related service needs of relative caregivers who step up to raise DC children and their extended families in times of crisis when the children's parents are not able to care for them. Many of these children come into the care of relatives after the children have been abused by their parents. We are testifying today to express our concerns with some aspects of this legislation. First, the typical process for legislation that impacts child welfare would be for stakeholders in the child advocacy community to be invited to comment on the proposed legislation and for the Committee on Human Services to hold a hearing so that stakeholders and the members of the public would have the opportunity to testify. The involvement of stakeholders is important to legislation such as this because it is addressing much more than background checks for teachers. These background checks are relied on to ensure the safety of children when licensing social workers, residential treatment and staff, nurses, medical and mental health providers, daycare workers, and foster parents. By only including government agency representatives in the drafting process and including drastic changes to child welfare laws in an education bill, the Council is missing critical input and giving the appearance of not being transparent about the process. Second, according to the U.S. Children's Bureau's review and expunction of central registries and reporting records, DC's current law, which does not provide for expungement of substantiated reports, is consistent with the majority of other states, which is currently 30 states. Moreover, only 5 states, Arkansas, Illinois, Iowa, North Dakota, and Utah, provide for expungement of substantiated reports after 5 or fewer years. Of the remaining 15 states, 7 provide for expungement only after the child becomes an adult, 5 provide for expungement 10 years from entry on the register, and 3 provide for expungement after 7 years. Third, our work with relative caregivers, children, and families touched by the DC child welfare system has identified various practices CFSA utilizes when a child has been abused or neglected. One of these practices is known as kinship diversion or hidden foster care. It occurs when CFSA substantiates abuse or neglect and determines it is not safe for a child to remain in their parental home, and rather than remove them to foster care, CFSA will ask a relative or godparent to step in to take the child. This most often occurs under a threat of removal to foster care so that the parents and relatives feel coerced into agreeing to the arrangement. This practice has been studied by various organizations, including the Annie E. Casey Foundation and Child Trends, which have found that hidden foster care is so common that it occurs roughly as frequently as formal foster care, and the decision to remove a child rather than divert is typically made because of a lack of appropriate family members, not due to case-specific concerns, such as the severity of the abuse or neglect. This is consistent with what we see here in DC. CFSA will look to divert a child first before ever considering removal, and will do so as long as there is a willing relative, regardless of the type or severity of maltreatment, age of the child, ability of the relative to care for the child, or other factors. In light of the prevalence of kinship diversion, we cannot assume that just because a child was not removed from their home to foster care, the abuse was not severe. If we base the amount of time for expungement on whether a child was removed to foster care, we will ensure that perpetrators of similar levels of abuse will be treated dissimilarly, based solely on whether the child was diverted to hidden foster care or formally removed to foster care, and not the severity of abuse. Finally, we note that the types of abuse that are excluded from expungement under this legislation are too narrow and should also include sex trafficking, burns, broken bones, torture, medical abuse, and evidence of repeated physical abuse. Thank you for providing me the opportunity to testify, and I'm pleased to answer any questions.
Thank you, Ms. Keller. think we'll have one round of questions. I just have a couple. Oh, wait a minute. I'm told that Marie Cohen has joined us. Ms. Cohen? Yes.
Yes, I did join. Yes, I did join.
Okay, you were number 7. Why don't you proceed?
Oh, okay, great. Thank you very much. Good afternoon. Let's see, let me fix my camera here. I'm really bad at this. My name is Marie Cohen. I am a resident of Ward 6, and I write the blog Child Welfare Monitor, a national child welfare policy blog that attempts to cut through ideology and misinformation and provide a clear-eyed discussion of issues. I also serve on the District of Columbia's Child Fatality Review Committee, and I'm a former foster care social worker in the district. I'm here to testify on the Educator Background Check Streamlining Amendment Act, and specifically on the provisions related to the Child Protection Registry. To summarize my testimony, I agree with the bill's framers that some people with substantiated reports of abuse or neglect should be able to have their names expunged from the registry. But the changes embodied in this bill put the district well beyond the mainstream of states in terms of the ease and speed of expunging registry entries. Several misleading assertions in the statement of introduction cast further doubt upon the bill. And aside from the merits of the bill, such major changes should not be made without a survey of state policies, public input, adequate notice to parents and advocates, and hearings by the Human Services Committee. Creating several tiers of child maltreatment findings with different requirements for expungement makes sense. Not all offenses are equally severe, and people can mature over time. But as the last speaker said, the district is already in the majority, along with 27 states that have no provision for automatic expungement of substantiated reports. While no two states have identical processes and standards, the districts are squarely in the mainstream of other states today. Moreover, the radical changes being proposed in this bill would put the district well outside the mainstream. Only 6 states allow expungement of any substantiated reports in as little as 5 years. And maybe I got it wrong, I think she said 5. And usually only for certain types of reports, with others taking longer to expunge. The sponsors of the bill assert without evidence that most substantiated allegations in the Child Protection Register will also appear in another registry like that of MPD, the FBI, or the Sex Offenders Registry. The signers appear to imply that these findings are so trivial that the perpetrator poses no danger to children. In doing so, they state that findings of neglect often have more to do with income and less to do with a caregiver's suitability to supervise children in a professional capacity. But this trope that neglect is synonymous with poverty is not supported by the facts. Substantiated findings of neglect often involve parents who leave their children alone for extended periods of time, drop them off with unsuitable caregivers, fail to get them to school regularly, or let their home become unlivable. Serious substance abuse is often a contributing factor in such cases. Neglect can be fatal. In short, it is an error to belittle the severity of neglect. The sponsors also suggest that findings of abuse that do not arise to the level of a criminal charge are necessarily minor, but this is not the case. Criminal courts have a much stricter standard of proof than does CFSA, and there are cases of death or injury that are substantiated by CFSA but do not even result in charges by the police, as I know from serving on the citywide Child Fatality Review Committee. That means the perpetrators of some very serious abuse, such as whipping a child bloody or knocking them down or torturing them even, may not show up on a criminal registry. I'm frankly offended that this bill came out of the blue for those of us who advocate for abused and neglected children. No change to the registry should be adopted without a survey of policies in other states and a request for community input. The result should be a bill dealing with the registry alone, a bill that is introduced with enough advance notice to parents and child advocates and receives a hearing by the Human Services Committee. Reforming the child abuse registry is a worthy objective, but a weighty one, necessitating thorough investigation, honest advocacy, and clear-eyed consideration. Thanks very much for your time.
Thank you, Ms. Cohen. So we will have, I think, one round of questions. I think I'm going to start with you, Ms. Cohen, maybe not so much a question. Please don't be so offended. This is a bill that was introduced. It was introduced September 16th. The purpose of the public hearing is to hear testimony. Now, it could be that all the council members or I, as the chair, I'm stupid, but I'm actually, and I'm not saying you said that, but and that we don't get it, but the hearing is an opportunity to hear comments and to look at the concerns that are raised at the hearing. That's what these hearings are about. And there's actually additional safeguard, because if I am stupid and I completely disregard everything you say, it still has to get to the full council with 2 readings and a markup. So there's lots of opportunity for folks to step up and speak out and say, hey, we're making a mistake. My primary concern with this legislation, my primary concern with which this legislation deals, is the speediness of the background checks. And I don't know that I consider expungement to be central to that. And I will talk with other council members, including the author of the legislation and our Judiciary Committee chair, with regard to expungement. So I'm just, and then this isn't really meant to ask for a response from you, but folks should not be offended, but they should speak out and speak out strongly if they think that there's something that's a mistake in the legislation. I did have 2 questions.
Yeah.
I had a question for Ms. Pitts, but you weren't the only one, Ms. Pitts, who testified to this. We're worried about the potential removal of the requirement that LEAs contact any of the candidates' former employers to inquire about possible child abuse or sexual misconduct. So the bill is introduced, contemplates removing that requirement. That doesn't prevent you from doing those inquiries. But I'm concerned about how long it takes to get through these background checks.
Sure.
It depends, of course, upon how much involvement an educator or an adult has with kids, and that was somebody else's testimony, and I think we need to look at that. So my question to you really has to do with the time. You want the requirement, but I'm assuming that you, as with many other LEAs, are concerned with how long this process takes. So can you just speak to that, reconcile the two?
Sure. Thank you for the question. One of the recommendations we make is to allow staff to begin working after they've cleared what we think are the most critical hurdles, the criminal background check process and the National Sex Offender Registry check. After that, it could be sort of a matter of continuation of employment, and employment would be conditioned upon passing the other checks. And so we're concerned that the legislation that informed SOA, or the thinking that informed SOA, it'll be too dramatic a change to take away entirely the responsibility to check with prior employers. But we don't think it would be problematic to let someone work on a conditional basis while those checks are performed.
Okay. All right, and I actually think that makes sense, to a conditional hire, and then if the check comes back with some bad information, that then action could be taken. Oh, that's helpful. I had one other question, and it was for Ms. Cote. I hope I'm getting better at this. You make several references to the Children's Justice Act Task Force, which I believe was 12 years ago. So where do we find those recommendations?
So the recommendations are held confidentially by the task force, which is, I think mostly run out of CFSA, which I agree is very frustrating. In the context of these legislative amendments that are being considered, we just this morning got permission to share. We are privy to the recommendations because CLC is part of the task force and part of MACAN. But these documents are not publicly available, which I recognize makes it very hard to talk about recommendations that are not publicly available. My understanding is that the legislation was informed by the recommendations and that there's been close coordination with the agency on the expungement piece with the agency. But the agency just told us this morning that we can at least start to be able to share those recommendations with council and council staff who are working on the markup. So we're going to reach out and be able to share those if they're helpful to you all.
Well, I guess that leads to 2 questions. One of them is, so can you share something in writing that is the recommendation, at least this recommendation that you referred to?
Yes, yes, I think so,
Right,
with
so
the
you-
council.
So you have some homework there.
Yes.
The second question, which is maybe not your responsibility, why would there be a task force with recommendations that are confidential?
I don't know. So that's a good question, maybe for CFSA. But I know that the work of the task force is ongoing, and I know that it is broad. I mean, it's a big group of stakeholders across the city, and so I will just say that we really do support the work of the task force, and think that it that some of my fellow panelists talked about wanting there to be careful study and looking at other jurisdictions and research in going into this type of legislative change. And I will say, I do think the task force recommendations did do that. They're supported by years of research and focus group, investigation and consultation. So we are really hopeful that once the council can see those recommendations and sort of maybe get some of the background of what went into them, that can give you more confidence in what they're based on.
Okay, I'm still kind of stunned here. I'm looking at my colleagues and wondering maybe we could set up a few task forces in which we direct them to come up with conclusions and recommendations that they don't share with anybody. And at least that way, nobody will be frustrated that nobody paid attention to their reports, because nobody will see their reports. I'm sorry, I'm being a little sarcastic here, but okay, that was a little breathtaking. Thank you. Councilmember Henderson, do you have any questions?
I do, Mr. Chairman, and I appreciate your comments at the top. We did work with CFSA, who had access to those recommendations. So I'm going to try not to take personal offense to some of the comments, as though my office didn't conduct any research prior to drafting this legislation. And I'm going to move on. Ms. Pitts, you made reference to DCHR's services for screening suitability. And you said 20 LEAs participate in that, but then you also said it should be free. How much are y'all paying for DCHR to?
At this time, for the full scope of services that are required under SOA, or for full screens that are required under SOA, we pay $102
Per applicant?
per candidate. Yes.
Oh, that's interesting. And how many campuses does KIPP have?
Well, we have 20 schools, 7 campuses.
And when you all send from a process, I'm trying to get an estimate here. From a process standpoint, for one position, how many people might you send through that process? Do you send just your final candidate, or do you send the final 2 just in case?
Let me double check that. I think it's just the final candidate. But certainly if someone doesn't pass screening, we may have to send another one through that process. So I think it could be more than just the cost of the number of vacancies that we're incurring.
Okay.
And of course, we're recertifying every 2 years. So there's more expense associated with going back and doing the review process for our existing staff every 2 years.
And how long is it taking for DCHR to turn around your screening?
The parts that we think should happen before someone enters the building just take a couple of days, a few days to do the criminal background check process. Now, if there's a hit, I imagine that can take a bit longer. But for someone who doesn't have a concerning history, let's say that's 3 to 5 days. For the full process, more like 4 weeks.
4 weeks. Okay.
But the National Sex Offender Registry is very quick, and the criminal background check process has been relatively quick as well.
Right. Okay. That's just very interesting. I'm assuming DCHR offered that to all of the LEAs to opt in.
The Public Charter School Board, and I can verify myself and get back to you if I'm not right about this, but the Public Charter School Board created the relationship with DCHR and offered this service to the public charter schools.
Okay. Now I'll ask this question to both Ms. Pitts and Ms. Warsinga Koti. You both brought up around the requirement that LEAs contact the employer, which I would assume, I think for us, it was okay, isn't that something they would already do in terms of a reference check? Although I guess an LEA leader would just be thinking more from an academic framework. But the requirement as it is currently written is to contact each employer in the past 20 years, which in like millennial timeframes, that could be 4 to 5 jobs on the conservative end. Would you all be open to, do you feel like a 20-year look back is still appropriate? Let me just ask that in terms of like what we're talking about here.
Well, Councilmember Henderson, I think that one of the proposed amendments is also to shorten the applicant history that they have to submit to 7 years,
Right.
from 20 years to 7 years. So, and then that requirement of contacting former employers refers back to that first, the applicant must submit information requirement. So I think combined, or if you take that into account, then this requirement in subsection 3 would only require talking to 7 years worth of employers.
Okay.
Which is less burdensome than 20 years. But again, like, I mean, I think we agree with you that you would hope anyone hiring a teacher would talk to the other places they had worked. But, you know, this lays out the minimum requirements and what schools are going to be legally held accountable to. So feels like a really important one.
Right. Do you feel like the 7-year look back is appropriate, or would you prefer for something longer?
We don't have a problem with that proposed amendment.
All right, Ms. Pitts.
Very much the same. We are in agreement with the 7-year look back, with shortening the look back period. We're just concerned about, and I think we're just asking you all to take additional look at this.
Yeah.
What the potential effect could be on predatory behavior if we were to remove entirely the requirement to contact former employers. The reference check doesn't quite get us there, because you can list a colleague or probably a personal reference. It doesn't even have to be necessarily someone associated with one of those jobs. So, you know,
right, but we know that people, well, at least I do. You may give me the list of your references, but if I know someone at an agency or organization where you previously worked and you didn't list it, but I know someone, I'm going to call just to see.
Sure. And I think that's, you know, you're very careful, and I hope many employers would do something similar. But again, I think it's not quite the same as having to list those employers and having to answer the specific questions that SOA requires at this time.
Okay.
But we're certainly fine with a shorter look back period.
Yeah, I'm not opposed to that. And I think Ms. Wersinger-Cote, you bring up a really good point in terms of, I think it's A3 references to A1. So if we change the look back period in A1, then they wouldn't necessarily be out of whack. Mr. Chairman, I don't really know how much time I have because I started at the end of your clock. So I'm just trying to make sure I get my full 10 minutes, but I don't want to be inappropriate because I know Ms. Indo is waiting.
Well, you were doing fine until you called yourself on the time, but keep going.
It's fine. Fine with me. Go ahead. You're on a roll.
Okay. Okay. Ms. Wersinger-Cote, you mentioned about listing the conditions. Are you concerned that if we list conditions as opposed to a broad stroke that we will miss something? That's always the trade-off of like listing out.
Sure. I mean, I think the CJA task force recommendation makes a lot of sense because it's a list of including, you know, it's seriously, you know, it's not necessarily limited to, but even within that definition, you know, there are some categories that are broader, like things that involve hospitalization, and things like that. And so our main concern, I mean, we do think that a lot of research and thought went into the CJA task force recommendation. So, you know, our main concern is what's in the proposed legislation is very narrow. I think that might be an imported criminal standard that's quite high.
Yeah.
And so there's a lot that falls in that gap that is still very serious violence, intentional violence against children that we just want to make sure stays on the registry. The people who commit those acts stay on the registry.
Right. Okay. And then your testimony about a petition process for expungement. is completely in the opposite direction of what many criminal justice organizations are advocating for in terms of expungement for things that are in the Judiciary Committee. And so the concern being is that what if people don't know that they're eligible? What if people don't know what the process is?
So I am, yes, so I understand. And again, this is coming from the CJA task force recommendations, where petition-based process just can be as minimal. It doesn't have to necessarily be like a big court involved process. It can just mean a program administrator review.
Okay.
But the point being that it's someone is taking responsibility and held responsible for making a decision, because in a lot of these cases of substantiated reports of child abuse and neglect, there's circumstances that need to be taken into account as to whether was this intentional or are there circumstances that make it not someone who's intentionally, and I can go through examples and stuff like that, but the circumstances of a report are relevant to where it should fall on tier 2 versus tier 3.
Yeah.
Like, is this something that should never be expunged? Is this something that reasonably should be expunged? And so we're just concerned with a system that it's like when a certain date passes, boom, it's deleted and no one's exercising any judgment or review. A program administrator review does not need to be very lengthy or complex. It can be a phone call. It can be, it doesn't have to be a very complex, lengthy procedure.
Okay. And then finally, I know Dr. Reed isn't here, but she presented testimony around the desire for schools in her community and communities there to have violence interrupters as part of the process in schools. And Ms. Dankula, I want to bring you in because you work on out of school time. Many, not all, of those who are violence interrupters do have things that will pop on a background check that might prevent them from entering a school under our current law. How did you receive her testimony and sort of the suggestion that we make modifications there? That's open to anyone.
Thanks for that question. I think from the OSP coalition and our membership perspective, I think that was one of the equity issues that came up as far as like parents, for example, who would volunteer in a program and might have something in the criminal history. But we do feel like, the expungement period would be helpful. But I can also reach out and get more responses from coalition members about that.
Did anyone else have any thoughts on that?
Well, just to say, maybe if there's a specific program like violence interrupters where you're trying to create access, that maybe those programs, I think someone already suggested maybe having specific rules or a specific pathway for people in that program, but not necessarily, lowering the standard for everybody who's applying to work in schools versus, people trying to work through that specific program where you want that specific expertise.
Okay. Thank you all for your testimony. Thank you, Mr. Chairman.
Thank you, Councilmember Nadeau.
Thank you. And I'll just say maybe a little bit from my opening statement since I got here a little late, but I do want to thank you, Chairman, for convening the hearing today, and thank Councilmember Henderson for her work on this. So we know that schools have been struggling with background check backlogs for years, and it's sort of been various iterations of it. So in Ward 1, we experienced the same issue with some reforms making it so that violence interrupters could no longer be in the schools where we needed them. We've certainly experienced backlogs for volunteers, parents getting into the schools and helping. During COVID, this was a big thing because we needed more hands on deck to get things done as schools were reopening. But it's really always been an issue so always. The 8 years that I've been here, folks have been raising this pretty consistently, even though it's evolved, the complaints and the concerns have evolved. So I do appreciate that we're really having an opportunity to be thoughtful about this through the legislation. Having CFSA here today really helps. I know, Marie, you're such a strong advocate in this arena and have a really deep well of experience. So I appreciate your insights, and just know that, we also, we've got all of the child welfare advocates here today weighing in, and CFSA will be here. So we want to get this right. We all have the same goal here, I think, which is to ensure we can keep kids safe in schools. And that means ensuring the people who are with them are properly screened, and also that there are enough people in the schools to be serving kids in the ways that they need. So it's a tough balance to strike. If it wasn't, we would have done it already in the various reforms that we've done over the recent years. Anyway, that is to say that I'm really grateful for the testimony here. Carlene had to go, but I do want to shout her out for really raising that VI issue front and center. And Tammy, thanks as always for your testimony. I think I'm really interested to hear from Director Matthews on these issues, and to hear him respond to the discussion here today, in particular around the registry. Because I think we certainly want to make sure we're doing no harm, but I know that a great deal of thought was put into the bill before introduction. So I think I will leave it there so we can keep hearing from folks, but let me just double check if I have. I think let's keep it moving, but I just really appreciate all of your testimony. Thank you.
Thank you. Thank you.
Thank you, Councilmember Nadeau. Thank you, each of you, for your testimony. Dr. Reed was going to submit her statement. I don't believe anybody else joined us who didn't testify. This testimony has all been helpful. Thank you very much. So you all are going to be excused. You can continue to watch the hearing, and I'm going to call the two government witnesses.
Oh, okay. Thanks. Okay. All right.
And the two government witnesses are Sharon Gaskins, who's listed as Resource Strategy Officer at the District of Columbia Public Schools, or DCPS, and Robert Matthews, who's Director of the District of Columbia Child and Family Services Agency, CFSA. Apparently, when we let folks into the room to testify, we're promoting them. So congratulations to everyone who was just promoted. I don't think it follows, though, that when you're done testifying and we excuse you, that you're demoted. I don't think that's, we say you're excused. But give us a second here. Our witness list has Ms. Gaskins going first. Is that okay? Mr. Matthews, is that okay? Ms. Gaskins, you're up.
Okay, great. Thank you very much. Good afternoon, Chairman Mendelson, members of the council and staff. I'm Sharon Gaskins, Resource Strategy Officer at DC Public Schools, or DCPS. and I'm honored to testify before you on the topic of educator background checks for DC Public Schools. DCPS appreciates and supports the intent of B24989, which we believe will greatly enhance our efforts to hire talented staff across the system while continuing to implement important safeguards that keep our students safe. We would also like to take this opportunity to suggest further refinement of the bill and address implementation challenges related to the addition of the Child Protection Register, or the CPR check, in the School Safety Omnibus Amendment Act of 2018, or the SSOAA. Pre-existing DCPS background check procedures. Prior to the SSOAA, DCPS had already implemented a comprehensive background check process required by statute in the Criminal Background Checks for Protection of Children Act of 2004, or the CBC, that captures any criminal act, including instances of abuse or neglect for which there was an arrest or a conviction. Further, the CBC Act has a 7-step process required for the evaluation of background checks that DCPS follows, except for cases of sexual offenses involving a minor and sexual felony offenses for which applicants are immediately deemed unfit for service in our schools. For all other acts, DCPS considers 7 factors to determine whether an individual poses a present danger to children or youth, and therefore may not serve as an employee or an unsupervised volunteer. The factors that are considered include the duties and responsibilities of the job position, whether the criminal offense for which the individual was convicted will affect their fitness or ability to perform their job duties, how much time has elapsed since the criminal offense occurred, the age of the individual when the criminal offense occurred, how frequent or serious the criminal offense was, information about the individual's rehabilitation or conduct since the criminal offense occurred, and the benefits for the ex-offenders to obtain employment. Our investigations unit conducts these reviews with an evaluation rubric aligned with the Act in consultation with our Office of General Counsel. This required process ensures the integrity of our hiring practice in accordance with DC Code and ensures that individuals are not cleared for employment with DCPS if they pose a present danger to children. Current DCPS background check procedures. Our current background check process includes several elements, each with its own turnaround timeline. These timelines are dependent on the actions of individual applicants in terms of completing steps and correcting errors as needed in a timely manner. These steps include the criminal background checks, or fingerprints, which take approximately 2 days for no criminal record to 60 days for those with a criminal record. The National Sex Offender Registry, or the SOR, 2 days to 5 days. The DC Child Protection Register, or the CPR, 14 days. Tuberculosis screening, which is variable, dependent on candidate self-reported results. And mandatory drug and alcohol testing, or MDAT, which is 5 days for a negative specimen to 14 days for a positive specimen. When executed quickly and smoothly, the process has traditionally taken a candidate approximately 3 weeks to complete. To further expedite the process, DCPS has made data system improvements and assessed its suitability matrix to allow for a tiering of applicants based on their role in the school. However, we have experienced delays due to the volume of checks needing to be processed by CFSA and the time-intensive nature of conducting the CPR check. Challenges with the implementation of CPR checks. After the SSOAA was enacted, DCPS reviewed guidance provided by the Office of the State Superintendent of Education, or OSSE, and worked diligently to partner with CFSA to implement the CPR requirements of the Act. However, implementing these requirements has caused challenges, which we anticipated when the Act was first proposed. While the addition of the CPR check for employment suitability purposes in a school setting was well intended, its utility is limited to determine fitness for duty. We note that the majority of substantiated CPR reports, i.e., those that do not involve an MPD investigation, are for reasons of neglect, such as inadequate supervision or educational neglect. These reports do not rise to the level of criminal charge. Further, any information that would be relevant to determine fitness for duty is received through a previously established background check process as established by the CBC Act that I referenced earlier. To implement CPR checks, CFSA conducts checks of the District of Columbia's local database. It is important to note that each CPR check requires a manual search through CFSA's investigation history. While CFSA has created a unit dedicated to processing DCPS application has been a very strong partner in this work, the volume of checks required is overwhelming. To strengthen the capacity of CFSA, DCPS provided funding to the agency so it could add staff during the height of the hiring season. We also made several systems improvements, including eliminating a third-party vendor to streamline the process, launching a quick-base application to make the process more user-friendly for applicants and automated for staff, and connecting the quick-base database between DCPS and CFSA to facilitate information transfer. However, the complexity and the individualized nature of the checks limits the efficiencies that can be achieved through automation and standardization. Thus, implementation remains a challenge to the continuity of operations for DCPS. In essence, we are hamstrung by a process requirement that does not increase student safety. In conclusion, DCPS is proud of the process improvement it has made and is grateful for the Council for introducing a bill that will remove some of the legislative hurdles to further streamlining the clearance process without compromising student safety. To further strengthen the bill and the process, DCPS recommends removing the CPR check. This will ensure that the CPR check is used for its intended purposes and not employment suitability for staff, contractors, and volunteers in school settings, and will reduce redundancies within the criminal background check, which will capture any report of abuse or neglect for which there is an arrest or conviction. The removal of the CPR check will also have the beneficial effect of greatly expediting the clearance check process. Thank you for the opportunity to speak before you today. I am happy to answer any questions that you may have at this time.
Thank you, Ms. Gaskins. Mr. Matthews.
Thank you. Good afternoon, Chairman Mendelson, council members and staff. My name is Robert L. Matthews, and I'm the director of the DC Child and Family Services Agency, known as CFSA. Thank you for the opportunity to testify before you today in support of Bill 24-989, the Educator Background Check Streamlining Amendment Act of 2022. I'm joined today by members of CFSA's executive team, Michelle Rosenberg, who is the Deputy Director for the Office on Planning Policy and Program Support, and Elizabeth Muffaletto, our Deputy Director for Entry Services. I would like to thank Council Member Christina Henderson for her leadership in introducing this very important piece of legislation, as it will make some important improvements to the current School Safety Omnibus Amendment Act of 2018, SOA, while ensuring an appropriate screening process for individuals who have direct access to children. Being listed on the Child Protection Registry, known as the CPR, can impact an individual's ability to find certain forms of employment, participate in school activities, provide kinship care, and serve as a foster parent. Additionally, it will amend the current expungement law and address harm done to individuals and in turn their families who have found themselves placed on the register for infractions that do not warrant a harsh, lifelong penalty. And finally, CFSA supports an amendment to the Prevention of Child Abuse and Neglect Act of 1977, included in the bill to remove the notary requirement for CPR check applications. My testimony today focuses on two primary substantive issues. First being the requested removal of the CPR component of the background check process. CFSA is responsible for conducting investigations of reports of alleged child abuse and neglect when the alleged perpetrator is the victim's parent, guardian, kinship caregiver, day-to-day caregiver, relative, or godparent caregiver, or custodian. There are three possible findings for completed investigations: substantiated, unfounded, or inconclusive. A substantiated report is a report that is supported by credible evidence, and an unfounded report is a report which is made maliciously or in bad faith, or which has no basis in fact. An inconclusive report is a report which cannot be proven to be either substantiated or unfounded. By law, CFSA is required to maintain a CPR, which must include for each substantiated or inconclusive report of child abuse or neglect the identity of the person responsible for the abuse or neglect. Currently, substantiated reports are never expunged, and inconclusive reports are expunged either 5 years after the closing of a CFSA case or the 18th birthday of the victim child, whichever occurs first. We urge the council to include in this bill the removal of the CPR check from the Educator Background check process because the CPR check is primarily intended for individuals in a parental or custodial role, not school staff, contractors, or volunteers. Without the CPR check, the background check process will still include a federal and local criminal background check and a check of the National Sex Offender Registry, which would effectively capture any report of abuse or neglect for which there was an arrest or conviction. It is important to note that CFSA does not investigate reports of abuse or neglect when the maltreater is not in a custodial role with the child, like that of a parent, guardian, or family member. For school personnel, if a teacher or other school employee is reported to have abused a student, CFSA does not have jurisdiction to investigate. The report is referred to Metro Police Department, MPD. Similarly, if a teacher is the confirmed perpetrator of abuse of a student, the CPR check would not provide any history of that abuse. That history would only be included in the findings of a criminal background check, and I would add if there was an arrest or conviction. Adding the CPR check for employment suitability purposes expands its use beyond the original established purpose. Prior to SOA, CPR checks are legally required in the district for two primary reasons: child welfare purposes, to license a foster or adoptive home, or to make a custody decision for a kin caregiver. Second, employment purposes, as part of the background check process for staff in a residential facility or a licensed child care provider due to a role being a custodian of children. CFSA is the only entity that can process CPR checks for the District of Columbia, and CFSA staff cannot search registers from any other state or jurisdiction. Each jurisdiction maintains its own database of confidential social investigations and findings. Requests for CPR checks must be made separately to each jurisdiction where the applicant has lived or worked. Few jurisdictions have an online application process. Most rely on printed applications that must be mailed or faxed, and the turnaround time for results easily exceeds 14 days. CFSA does not have the authority to conduct CPR checks in other jurisdictions for school employees, and states may not share information with CFSA as the agency is not the licensing or hiring entity. In cases where a report of abuse and neglect rises to the level of a criminal act, CFSA and MPD will conduct a joint investigation. For criminal matters involving abuse and neglect, MPD, in conjunction with the United States Attorney's Office, would determine whether to prosecute. The criminal background check conducted for any DCPS staff member, contractor, or volunteer would capture a criminal complaint related to abuse or neglect through arrest records and or convictions. It would not capture a substantiated finding of abuse or neglect made by CFSA that MPD did not believe rose to the level of a criminal act. The majority of substantiated reports do not include an MPD investigation or for reasons of neglect, such as inadequate supervision or educational neglect. An unintended consequence of the CPR check requirement is the disparate impact of applicants of color who may face a permanent barrier to school-based employment when listed on the register. The majority of allegations reported to CFSA are substantiated for neglect, and they occur because of circumstances of poverty. Due to the demographic makeup of the district, that means that almost all individuals who are listed on the register are people of color from low-income communities. Being on the register and potentially being barred from employment with children exacerbates the challenges faced by these families. The second part of my testimony will cover the amendment of the expungement provisions. In 2017, the DC Children's Justice Task Force reviewed the expungement provisions of the CPR law and the long-term impact permanent placement on the CPR had on families. The permanent placement on the CPR often has negative consequences for the children and families the agency seeks to protect. This is in part because no distinction is made for minor offenses, as opposed to those that are criminal or severe in nature. A person can be placed on the CPR permanently for one bad parental decision that meets the legal definition of abuse and neglect, but not severe enough to warrant separating the child from their family. For example, a parent with poor or unsafe housekeeping behaviors that puts a child at risk of harm would be subjected to the same consequences under the current CPR law as a parent who intentionally burned their child as a form of punishment. The law also does not take into consideration that an individual may be rehabilitated and supported to being a safer parent. For example, a young parent found to have neglected their child will permanently remain on the CPR, even if they successfully complete the service plan recommended by the agency, reunited with their child, and there are no other further allegations of abuse or neglect made against them. Individuals who are listed on the CPR are being barred from jobs in the childcare industry and professions that involve direct contact with children regardless of the severity of their offense. Individuals have had employment offers rescinded, been terminated from their jobs, or not been allowed to participate in their child school activities and events that require parental background checks because of permanent placement on the CPR. As I mentioned, these consequences disproportionately impact people of color. Data from around the country show that people of color are more likely to be reported to Child Protective Services for minor offenses than their white counterparts. The current law requires that substantiated findings remain on the CPR indefinitely and permits inconclusive findings to be expunged after 5 years. In line with the recommendations of the task force, this bill, if passed, will amend the law and allow for a 3-tiered system. Tier 1, inconclusive reports would be expunged after 1 year. A new inconclusive finding would extend that time by 1 year from the newest finding. Any new substantiated finding would extend the time from the newest substantiated finding by either 3 or 5 years as provided in Tier 2. Tier 2, substantiated reports except those reports that fall into Tier 3 will be expunged 3 years after the date of substantiation if the child was not removed from the home. If the child is removed from the home and there was an adjudication of abuse or neglect, then the substantiated report will be expunged 3 years from the date of reunification or 5 years from the date of substantiation, whichever occurs first. Any new substantiation or inconclusive finding will extend the time by 1, 3, or 5 years. Lastly, Tier 3, substantiated reports involving child fatality, sexual abuse, or serious physical injury can never be expunged. A 3-tiered system provides an opportunity for individuals who have been placed on the CPR to eventually be removed when certain conditions are met. In closing, we support this legislation and urge the council to add the removal of the CPR check requirement in order to expedite the employment process for staff, contractors, and volunteers working with students without compromising the integrity of the district's robust background check process. Timely staffing for schools, out-of-school time providers, and other partners have many positive implications for education in the district. Furthermore, we believe amending the CPR expungement law promotes fairness for families by removing a barrier that the lifetime rule has had on residents who are either seeking work or to take part in their child's educational experience through volunteering. Thank you for the opportunity to testify today. Before I say I'll take questions, I want to clear up the CJA recommendations gate. As the director of this agency, I have told no one that those recommendations could not be shared because I do not oversee the task force. And I hope no one on my staff did, but I will check after the hearing just to ensure. So, and again, these were recommendations back in 2017, of which I knew then. I don't think it's a top secret, and I don't think anyone would be holding them for any malicious reason. As Council Henderson spoke, my staff worked with her staff on drafting the legislation based on those recommendations themselves. And with that, I will yield and take any questions you may have.
Thank you, Mr. Matthews. So let's just start with that. The recommendations. So then where does this idea come from that their report and recommendations were confidential?
I'm actually not sure. I know Tammy very well at the Children's Law Center. We work very closely together. I think I don't know if she didn't have access to it, but I think she could have called me. I mean, I've had access to it, and I think my staff do as well. I do know that directive did not come from me.
Did the task force was set up how? By CFSA?
The task force is not set up by CFSA. We support it, but it is not set up by CFSA. Actually, it's a number of different stakeholders, along with other government agencies of individuals who serve on that task force.
Was it set up by statute?
I'm not sure. I have to check if it's set up by statute. I'm not really sure if they are or not. But we can get that answer to you.
Okay, so CFSA supports it. Does the task force report to anybody?
That's a great question. I know they do not report to me. But again, because I'm not in the I'm not on the task force, so I'm not really sure.
And who appoints the members of the task force?
So the task force was established in 2010 pursuant to the Federal Children's Justice Act grant to enhance the investigative, administrative, prosecutorial, and judicial processes that protect the interests of child victims of abuse and neglect. The task force includes professionals from across the district with expertise in the fields of criminal justice, physical abuse, child neglect, child sexual abuse and exploitation, and child maltreatment related fatalities.
So this was set up by a federal statute.
CFSA's role in it is to apply for the funds. And then we also do grant monitoring, and provide a report to the federal government on the activities of the grant itself, of the CJA.
And Chairman Middleton, I am told now that it is a federal requirement.
Okay, do you have the federal, do you have the
That's,
citation to the federal law?
we can share that with you. With your office.
Do you have it right now?
I do not have it handy with me right now.
Okay, please do share it with us. And so you'll make sure that we can get their recommendations with regard to, I think this has to do with the expungement.
Absolutely.
Am I on a clock? All right. So you're not in the gallery view, so I can't tell how many minutes I have left. I do have a few questions. The CPR. So the bottom line is that you would like to see that most of the instances where somebody is on the CPR, that they can be expunged.
That's correct.
And the CPR was not established by the School Safety Omnibus Amendment Act, was it?
No, it wasn't.
But I believe that that bill or law made amendments to the CPR statute.
That's correct.
And was
I believe it expanded the scope in terms of individuals who would be screened for employment for schools.
Part of the rub that I've heard with regard to the School Safety Act is that it requires checking every state registry.
So just a bit of clarification, and I'll make sure I'm saying the right thing. Of course, we only have jurisdiction over checking for Washington, D.C., but depending on how far you go back, or an individual that may send in an application, if they have addresses in other states, then for that to be a complete application, then the other state as well would have to check their own system. And again, we've seen in terms of our experience in seeing that far exceeds the 14-day time frame that really has been established as a turnaround time for an application. So in those circumstances, that would be on the other jurisdiction for where the applicant resided.
But my impression is that the way the School Safety Act was written, it only requires that check in states where the person lived or worked. Am I misunderstanding that?
I believe that is correct, where they have lived or, yes, or worked.
And that's still seen as burdensome, Ms. Gaskins?
Hi, good afternoon again. So I believe the language of the act says all available registries. And so DCPS and its implementation of it agrees and understands with CFSA that the registry that's available to the CFSA agency in DC is DC's registry. To expand beyond that would require individual outreach to states and as Director Matthews said, a prolonged hiring process because there is no one central database that exists.
Yes, but we're not looking to expand. With this bill, we're looking to streamline. My understanding is that you have to check every state registry.
So I believe the language of the act is every available state registry. And so as we moved to implement the SSOAA when it was first passed, we really did work to prioritize those actions that had the most immediate impact on student safety. So as you know, it includes the development of policies related to the prevention of sexual harassment. We did that very quickly, developed one policy on student sexual harassment, another on staff to student sexual harassment, new curriculum implementation, and also we prioritized the implementation of the DC CPR registry check. And so in that way, we believe we are aligned with the law and that we are accessing those state registry that is available to us and working with CFSA in that regard.
Okay, so but my focus here is on whether you're checking 50 states or you're checking only the 3 states, let's say, that an individual has lived or worked in. The language of the statute says reviews available child abuse and neglect registries of any state or jurisdiction where the person is known to have lived or worked. So that would be more narrow. Am I misreading the statute?
No, I don't believe you're misreading it at all. We reviewed what was available, and what's available to us here is the registry in DC.
You know, you're confusing me.
I'm happy to clarify further.
So if an applicant lived or worked in the last 10 years in Pennsylvania, Ohio, Maryland, and the District of Columbia, what state registries do you look at?
We review the DC registry for every applicant, as it's this registry that's available to us. In order to check the registries of each individual state, we would have to reach out to each individual equivalent of the CFSA agency to have a similar review and an individualized manual check for each applicant.
And do you do that?
We are checking the available registry to us, which is the DC CPR.
Okay, so that's the way you read it, as you only have to check DC because that's the only one that you believe is available. But you would support eliminating checking the DC CPR.
We do, for the reasons I shared and Director Matthews articulated.
So why do fingerprints take 2 days to 60 days? It says 2 days if there's no criminal record, 60 days if there's a criminal record.
Yes, thank you for that question. The 7-step process I outlined earlier is our way of ensuring that only individuals who are fit for duty are serving in our schools. So 2 days is the experience for the vast majority of our applicants who have no criminal background. The 60 days is the outer limit for individuals who do have a criminal background and do require further review by our investigations team in order to determine whether or not they're fit for duty.
So the 60 days is not how long it takes to get the fingerprints. The 60 days is how long it takes for you to do the subsequent investigation if there's a criminal background.
That's exactly right.
I may have a few more questions, but I'm going to go to Councilmember Henderson.
Thank you, Mr. Chairman. Ms. Gaskins, I want to follow up on a line of questioning that the chairman asked, because it seems to me that now DCPS and the charter LEAs are doing something completely different. So we have 20 charter LEAs who are using DCHR. And DCHR is not here to defend themselves, but I have to assume, and maybe Director Matthews might have some insight into this. My understanding is that part of the delay was the fact that we had to check all of these CPR registries. But to now find out that DCPS is only checking DC, help me understand what, because the law says every state.
If I could, I'll speak from DC's perspective.
Yeah.
So, because I know that, first of all, we need to acknowledge that, yes, there are delays. I think there are two pieces to that. I look at the increased volume of applications based on the passage of the law in 2018, but also one thing that we don't really talk about is what a complete application looks like. So for instance, as an example, CFSA cannot process an application that's not complete. And so when it's not complete, we send that application back to the applicant with specific instructions on here are the areas that need to be completed. We call those returns.
Okay.
As of today, we have 200 returns, right? So what falls outside of our control is when the applicant resubmits the application. So that's one part of the delay. The other part of the delay is, so everyone understands, when you are checking the system, it's not as if you're putting in someone's name and it's coming up, oh, are they substantiated or not? You have to do a very thorough search in our system to determine investigations, what's been the finding and other pieces. So it's not like a system where you click and then there's this automatic pop-up. That's another part. The third part of delays is when we have a 14-day time frame that's been agreed upon to return our results, we do have a number of entities that request an expedited review. That's an expedited review on top of all other reviews. And that's because if they need someone to be hired tomorrow, to me, you count 14 days back, but then you're sending it to us 24, 48 hours before. So these are really complex reasons for the delay. And then I will also say, when you're talking about the volume and when you're talking about manpower, I don't think that was necessarily considered during the time of the passage. So when you look at, I have data from the time when it was passed, from the pandemic, because now you didn't have really staff or those applications coming through. When we started ramping up, we have an increase of about 3,300 applications on top of all the others that we do. So I just want to kind of give a picture when we're talking about delays. There are very specific reasons at the delays. There are reasons that we try to fix from a process perspective, as well as those that fall outside of our control.
Can you share some of that data with the committee?
Absolutely.
So we can have
We'll
a
do
complete picture. So Director Matthews, when you all do the CPR check, you're only dealing with DC, or
That's
are you
correct.
contacting other jurisdictions?
No, just DC.
So who is contacting other jurisdictions? Because the proposed bill that we're here to discuss would say you would have to contact the other jurisdictions for the previous 7 years, but it doesn't seem as though anybody is doing that. So let's talk about that.
If I may, I'd say that the look back provision, which I think involves reference checks, is separate from the CPR registry check across what could be across 50 states for a candidate. That's an extreme example, but of course, and so in the way that we have approached this, as I've shared earlier, and I think DCHR would be the same because we work very closely, that we lean on the CPR check that is based here in DC, and LEAs that chose to contact individual states. Again, there was no, I can't say it enough, there's no centralized database for any of this information in the nation. We even searched for a third party who could do this search for us. And they said, actually, we'd have to contact every state. And some of the timelines are up to 5 months if you wanted us to do that. And so again, we really diligently worked to immediately implement the most critical aspects of the SSOAA, including developing this relationship with CFSA, iterating on how we can best and most efficiently make this process work for our applicants and candidates. But do recognize this is how we've been implementing it with the partnerships that exist, always aiming to improve. We think this legislation is a step in a very good direction, but do really strongly ask the council consider for the recommendation we put forward to even remove the requirement because of the rigorous nature of the remainder of our criminal background check process.
Okay. I think both of you might have been listening, and I hope you were listening into the public witness testimony. There were some public witnesses who testified in a previous panel that they don't believe there is, well, not they don't believe. They don't have confidence that in the strength of the overlap between what is being reported to CFSA or like what is showing up in the CPR versus what will show up in other parts of the background check. Director Matthews, can you speak to that a little bit in terms of their concerns that were expressed?
Sure, I think, and let me just say this, because I think we really have to put out the whole reason of what the CPR register is and its intent. The CPR register's intent is for parents, caregivers, godparents, anyone who has custodial oversight of a child, of their own child. And so when you look at the appropriateness of trying to subject an individual who wants a job at a school setting as criteria for employment, it just does not make sense. What does it tell you? What it will tell you is if they have possibly abused or neglected their own child. So when I look at the appropriateness, the real appropriateness for a CPR register is for a foster parent. Because a foster parent comes to the agency wanting to foster. They are providing full-time care to a child that's been separated from their parent. Why is that important? We want to know if they've abused kids, because they're with the kids all the time, with the exception of not being in school. We utilize that information to make clinical decisions if they will be an appropriate foster parent. A CPR check and the results of that provides no basis whatsoever. No one can provide any data or information as to whether it adequately captures whether a person is suitable to work with kids. So to me, it gets to the value and the reason why each state has a CPR register. It should not be used for employment criteria. Here's the last part I would say. Now that we're in the space of diversity, equity, and inclusion, and we're looking at all of our policies to align with that, it does not fit within that space. It does not provide the equity that we need for individuals who are seeking employment to be a deterrent for that.
Do we require childcare centers to conduct a CPR check?
Yes, we do. And that is also required through the federal government.
Okay. I think that a little bit different, right? We're talking about a different age group.
It's very different.
We're
Yes.
talking about an age group of primarily infants and toddlers who can't speak.
Correct.
Who can't walk in some cases, can't
Right.
dress themselves, the whole nine. Okay, so.
Because in childcare centers, even in the federal law, it speaks to a teacher or aide standing in the place of a custodian over children because of their developmental ages. So it is a big difference from children in childcare centers versus children in elementary or high school.
Okay. How many applications from all the various entities, daycare centers, et cetera, like how many checks are you all running on average? Do you have any of that data?
Yeah, go ahead, Michelle.
So the overall fiscal year 22 count, that was plus the SOA and plus the prior checks, was 22,899.
22,000.
899.
Okay, can you repeat all that? You're very hard to hear, or maybe
am
speak
I?
louder.
Okay, let me try to speak louder. The overall count for the fiscal year 22 of all of the child protection register checks is in the amount of 22,899. If you're interested in knowing the number of SOA applications that we've received, I can tell you that in FY21, we received 4,157 applications, and that increase in FY22 to 7,372 applications.
Okay, I'm over my time on this round. Thank you.
Councilmember Nadeau.
Thanks, Chairman. I think I'm only going to be able to stay for this round, so I'm going to try to be efficient. Director Matthews, Kin Care Alliance raised the possibility that basing expungement on whether a child was removed from a household would miss abuse or neglect that results in a diversion or informal family planning arrangement. Do you have concerns about that in this context?
Not only do I not have concerns, I don't even think that makes sense, quite honestly. First of all, we don't do diversion in the district anymore. I think they know that and we've reported on that. The second part, when you're talking about expungement, as the law is today, if you're on the CPR registry, you're on there indefinitely. There is no room for anyone to come off. And so again, based on our data, for those that are on the registry, it's because of neglect, not abuse, neglect. So as an example, if someone is trying to change and do better, be a better parent, have changed course, trying to get a job, the employer does not get the information as to why they're on the register. They're just going to know they're on the register. And if I put myself in the employer's shoes, I'm going to think the very worst. I'm going to say, oh, I don't want to hire you because you probably abused your child, right? That does not give anyone a fair chance to be employed. It does not give anyone a fair chance to lift their family out of poverty. And so this is one, as you can tell, I'm very, very serious about, because we have to right a wrong here. We have looked at other states. We are very aware of where other states land. And someone said earlier, if we're in the mainstream, well, great. Maybe DC can continue to be an innovator, but it's not for the sake of not doing the work. Anyone should know, we want to ensure that children are safe. That's the first thing that we have to do. But I do not believe that creating a pathway for people, one, to be rehabilitated, and two, if they've not had any subsequent substantiated reports, that we cannot, as a city, as we talk about the race and equity all the time, create a pathway to where those can be expunged, to where they can have an opportunity to set out a different course for themselves and their family.
Thank you. I appreciate that. Well, since we are, discussing changes to the register with this legislation, are there other changes that you might recommend, especially regarding the notice requirements and the due process protections for parents, and potentially any statute of limitations for people trying to get off the register?
I will say, yes, I did listen to earlier testimony from Tammy from Children's Law Center. We do not disagree. I think there's some amendment we can do to the definition on physical injury or harm. So we definitely believe that we can definitely make headway there. No issue there. We definitely would like to look at the notary piece, because we know that can be also a barrier. Not everyone has access or know where to go to a notary. They may not even have the money for that. We believe that is a barrier as well. I did have a question in terms of the statute of limitations. I just want to make sure I understood the question. So are you saying that if someone is on the register, that there should be some type of provision whereby they have a certain time frame to contact the agency to see, should it be expunged? Is that what you meant by statute of limitations?
I'm going to have to ask a friend here. Hold on.
Okay.
I'm asking if we can get rid of the 30-day statute. There's currently a 30-day statute of something.
I'm not sure.
Yeah, I'll come back to you.
Okay, no problem.
Thank you for asking the follow-up. So does federal law require jurisdictions to maintain a registry or register?
Federal law does not require that.
Speak on.
Oh, federal law does not require to maintain the registry. Federal law requires through Title 40 Social Security.
Louder. Can you start over and speak louder?
I think, yeah, you got to get into the director's microphone, I guess.
Oh, well, let me move over here.
Yeah, I think that's the
go
issue.
next to him. So the federal law does not require a register. What it requires are two aspects. One is the Title 4E Social Security Act requires that foster parents, prospective foster parents, must apply to get a register response for becoming a foster parent. Secondly, we had talked before about the child care licensing applicants that also need to. The child protection register is based on district law for us to maintain it.
Got it. What is the process of checking other jurisdictions' child protection registers? How long does that take and how much does it cost?
Well, that's not our responsibility. That's the applicant's responsibility in order to reach out to whatever that particular jurisdiction has. Each jurisdiction has its own time frame, has its own process.
That's cumbersome.
Yes.
Okay. How much probative value does a past substantiation of, for instance, inadequate supervision offer in determining whether it's safe for someone to work around children? This is getting at what Director Mathis was talking about earlier, really, I think.
Yeah, I think there's a lot of value in, how would I say this? There's a lot of value in when someone is on the register and over time, if they're not able to be off the register, there really isn't an incentive for an individual if they know I'm never going to be off the register. There's really no incentive for me to participate, engage in services, to even have a different change in behavior. I do believe, and based on my contact with people with lived experience, which I hear every month through our Thriving Families work, is that if residents knew who have had history with CFSA knew that there was a pathway, that many of them would feel compelled. Okay, let me see how I can get my record expunged because there's some things that I want to do differently. The other part of this is that we actually do have 2 success stories of 2 individuals who provided leadership on our Thriving Families work, who now, with our help, have become gainfully employed. So these are individuals, these are real life examples who've been impacted by, unfortunately, a system or a structure or law that has impacted them and their families. And through our help, having to try to get them employed. But if we can really think about how to apply an equitable lens, as we talked about the 3-tiered process, just think if they met the conditions of being rehabilitated as the language is being used, 2, they haven't had any subsequent substantiated reports, and that their record is wiped clean. Now, one thing I do not agree with, and Tammy from Children's Law Center, and I wrote it down, I do not agree with a petition-based process. The reason why is because that will be individuals who will then decide after they've met conditions to then decide should they be off. That no way aligns with equity, with our racial and equity tool. If they have met the conditions, we should have the logic in the system that they should automatically be expunged if they've done it. We don't need to continue to have people making subjective reasonings why they should or should not stay off.
Got it. So then I think that would get at the question I was trying to ask earlier, which is really, the statute of limitations for requesting to get off the register.
Yeah.
So it should be, if there's an automatic, then people don't have to worry about that. But is there a period of time in the beginning where folks can challenge being on the register and that closes out at a certain time?
I think in terms of currently, there are processes for, like, there's what we call a PAR hearing. There's a program administrative review.
That's the 30 days I was referring to, I think.
Okay. And then there's a fair hearing that they can have a fair hearing officer.
Okay.
Speak up.
With the fair hearing, it doesn't matter how long it's been since the investigation finding happened, we will honor that request.
Okay, that's helpful to know.
Yeah.
Do we have any data from jurisdictions that have expungement, whether there's been an effect on child safety?
We don't have any data regarding that, or we're not aware of any.
What's the policy reason for inconclusive reports being placed on the child protection registry?
Policy reason, I can't say why there's a policy reason. I would think that it's just in the law. I mean, I think just so everyone understands what inconclusive means is that there perhaps may have been maltreatment, yet there's not enough evidence to state who it is, or there may be insufficient. So it's in some ways still is impactful to an individual being on the register. My recommendation is that it shouldn't be on the register, because again, it's still a hit that I think an individual will take as having, oh, it's possibly it happened, but there was not enough fact and base to really come to a finding.
Okay, so I'm over time, but that's something that we should think about as we're moving this bill, whether or not we'd want to make that change too. So thank you very much for the dialogue on this, Director. Sorry to have to pop out, but I'll try to come back. Thank you so much.
Thank you.
Thank you, Councilmember Nadeau. So let me start with the register. I'm not sure I understand this. The Child Protective Register, the CPR, is a creation of local statute, correct?
Correct.
Not federal statute.
Correct.
If we were to repeal the local statute, you wouldn't, and I'm not saying we're going to, but if we were to repeal the local statute, the federal government would scream or they would be quiet?
Chairman Mendelson, and I'm just going off for my past experience. I am not 100%, I don't 100% say there's no federal statute that requires it, because I know that there is some law somewhere that every state has to have one. And I believe that would be a federal law that it falls under. If you give us and our legal people time, I think we can provide that information, but I'm probably sure that there is a federal law that requires it.
All right, put that on your list to follow up along with that federal citation regarding the that task force. Okay, is the Child Protective Registry only instances of neglect, or does it include abuse?
It includes both abuse and neglect.
Okay, because earlier you said that it's primarily about neglect, and neglect isn't necessarily something that we want to not hire somebody for because of.
No, I was saying that majority of the reasons why people are on the register is due to neglect, not abuse. So it includes both, but more people are on the register due to neglect.
And is it identified on the register whether it's abuse or neglect?
That's the interesting part. It is, but that's information that we have. That's not information that would be shared with a potential employer.
So if I ask you if Phil Mendelson's on the list and you say yes, it could be neglect or it could be abuse.
Absolutely. We're not distinguished between which.
And the CPR includes all substantiated instances, but also inconclusive instances.
That is correct.
Okay. And you have the register so that you can make decisions with regard to, for example, foster care, a foster parent.
That's correct.
If somebody's on the register, does that bar them from being a foster parent?
That does not bar them from being a foster parent. We utilize that information through the licensing process, for instance, what we call a home study. It just helps to inform whether we believe they will be suitable and appropriate to be a foster parent, but we use that information to make that determination.
Now, the reason why we're having this hearing is because we have this legislation that tries to make it easier for schools to hire. But you've said that the CPR really isn't appropriate for hiring decisions for our schools. But the CPR is used as part of the background check process for staff in a residential facility or for a licensed childcare provider. Correct?
That is correct. And that's also a part of federal law.
So it's because it's federal law, not because it's necessarily good policy.
There are two different pieces. Well, I look at it in two different ways, but I hear your question. I do personally believe it is appropriate to have a CPR check for those individuals for childcare centers. I mean, I believe that, and that is in federal law. I align with that philosophy. I think when we think about whether it's appropriate for any individual who's trying to apply for a job in a school setting, having that information to me is not going to inform whether or not they are a good teacher. What it will tell you is if they themselves have had an experience with their own child, not whether they can teach appropriately in a educational setting. And by chance, if they do have a kid, more than likely a school may not hire them for that particular reason. Again, not knowing whether it's abuse or neglect, because that's information that will not be shared to the employer.
I think this is kind of tough for us. The folks who are on the CPR are people in the district whom you've had to investigate.
That's correct. Correct.
And it would be everybody you've investigated where it's substantiated or inconclusive.
Yes, sir.
So I guess, and what we heard from DCPS is they don't check out of state. So if somebody comes here and they've been in 3 other states and we only check DC, it's useful, but not completely useful because it doesn't get the full history of the individual. If we check the CPR for hiring for DCPS, we get information, let's say there's a hit, as you put it, but it could just be neglect, and it could be something that what I'm hearing from you could be relatively minor in terms of neglect, and it could even be inconclusive, and they won't know any of that. So I'm right to jump in if I got it wrong.
No, you're correct. You're correct.
And so your thinking is that it could be a bit misleading. I get a, you punch in Mendelssohn and you get a hit, and it could be because of something 10 years ago that was a minor instance of neglect with my own kid. And that's not a reason why the school should not hire me to be the principal.
Yes, and you use the term misleading. I just think it's beyond misleading to me, because if it's 10 years and, if they've not had any other experience or history with the agency, and I mean, it doesn't allow them an opportunity again to be gainfully employed, which is not something that I believe is the values that we hold here in the district, and trying to give everyone a fair shot and try to make it equitable for everyone.
But it also could be substantiated abuse, and it could be more recent. And it could be for hiring a teacher who's going to be teaching 3rd graders, and we find it out later, has a little bit of a anger management issue and likes to hit kids on the head with a book. That's what my 3rd grade teacher did. And that would be of concern that would be of concern.
I think of it in a couple of ways. One, what you want to make sure is that there's not a sex offender in the classroom, first and foremost. When you think about abuse, again, and this is just my years of experience, 2 decades in child welfare, that information means that there's a situation between me and a child that I have or I have custody of. That may be totally different than me being in a classroom of children that are not mine. I'm there to do a job is to educate. And so, again, what does that information really tell the employer if by chance they're on the register? Or what does it tell you if they're not? I think what I'm saying, even in terms of, again, as we are looking at all of our policies through an equity lens, it does not fit within the space of making it fair and equitable for residents here in the district. And I echo what you just said. This is a tough topic. This is something that we've had to sit down and think about actually for quite some time. But the last part is in terms of the value and the appropriateness and use of the CPR register, we just I believe very strongly, should not be used as an employment criteria for anyone. It should be used when we have people, going to the child care center or potential foster parents who want to foster kids.
But you do use it for employment purposes with regard to licensed child care providers in residential facilities.
Correct. And that's because they are serving what we call local parentis. And these are kids, when you look at in terms of their age, yes, I think it is important to have that information.
So it's less about it being employment and more about it being custodial.
Correct. At that, That's the best
But
way.
is it prohibitive? So you get a hit, you put punch in Mendelson, turns out you get a hit. Of course, you'll know why. If you get a hit on me, am I automatically disqualified for working in a licensed childcare provider?
That would be a yes for based on the employer. You would not want to put anyone who has a background or history in terms of with a child welfare agency in a childcare setting. And I know that because I also used to be over the licensing in Tennessee for childcare centers.
But in my instance, it was neglect 10 years ago.
Understandably so. I hear you.
You still would bar me from being a licensed childcare provider or being staff in a residential facility.
Based on how the structure is today, yes. I mean, I think an employer would.
All right, so I'm nearly out of time, but I'm going to push ahead anyway. So, and because I'm hopeful that this will help Councilmember Henderson with her questions. So, Ms. Gaskins, where is the delay? We had testimony, for example, that in many cases, volunteers or staff were hired in a role in an after-school program, but never got the opportunity to work in the program because their clearance application took 6 or more months to be approved. At one program, 5 staff members who were hired for a program found other employment options while they were waiting for their clearance. Another program says more than 20 volunteers were accepted, but ultimately found other options because of the unreasonable waiting period. One respondent said they went through DCPS to get the clearances in September 2021, and as of July 2022 had yet to receive their clearance. And I have heard this from the chancellor, delays in the background checks because of this law for volunteers at schools, for out of school time, and even for teachers backed up. And yet on your testimony, you have 5 bullets. Criminal background check, 2 days. That's if there's no criminal record warranting or further review. I assume the National Sex Registry, which is 2 to 5 days, is done parallel, not sequentially. The CPR 14 days, the TB screening variable, and mandatory drug testing 5 days. Could be 5 days. So the longest here is 14 days. That's 2 weeks. So why is it taking it so long?
Yeah, thank you for the question. And I think the experiences we heard about today reflect different stages of our implementation of the SSOAA from the beginning when it was a PDF form that needed to be navigated by folks who might not have access to a computer to when we had a third party involved, and there were delays on that front until where we are now, which I think is due to our close collaboration with CFSA and the most streamlined position we have been in terms of having the CPR application embedded in our DCPS clearance application. So I think those examples really just show how we've been really grounded in focusing on making the process more streamlined and effective. I'll start with a few things, many of which we've shared earlier. The sheer volume is something that DCPS flagged when this act was first introduced. And the level of employees, contractors, volunteers, and the like who would have to go through this system was a major flag for us. And so where we see delays, it's not something we didn't anticipate. I would also say, as Director Matthews mentioned earlier, that window, even with the volume of delays, it's important to understand that the window only begins when CFSA receives a complete application. And so while we have worked hard to make the application as streamlined and clear as possible, and I think we've made really meaningful strides, if one piece of information is missing, that application is on hold until CFSA gets the information it needs. And that's a process that Director Matthews could speak to more in more detail, but it's very likely that a person who had an extended window for getting a clearance may have been in that space where more information was being requested and perhaps the applicant didn't receive the request, or there was confusion or something of that variety. The other thing I would just clarify is that the different checks that I talked through are initiated in different ways. And so things like the criminal background check, which is fingerprints, the mandatory drug test, those are applicant initiated. So we provide applicants the information to go set up a fingerprinting site visit, to set up an MDAT test, and assuming, which most applicants do, they do those things quickly, those timelines apply. The sex offender registry is different. We take information from each employee as part of the clearance application, and we work with DCHR to run the sex offender registry check. So that happens behind the scenes. There's actually no action required from the applicant. And again, we do know the actions involved with the CPR check. So I did just want to take this opportunity to outline the different ways this clearance process in total works.
So assuming no criminal record, the applicant, you guys will process the fingerprints, or somebody processes them within 2 days after the applicant goes and gets them.
That's correct.
And the National Sex Registry is 2 to 5 days after you get the application.
Yeah.
Stop me if I'm wrong. And the CPR is 14 days, but you want to get rid of that. And the TB screening is dependent on the applicant.
Mm-hmm.
And the mandatory drug testing is 5 days after the applicant has gone and gotten that.
For negative specimen.
So it still could be 14 days, except the volume has created a longer time span.
The volume is having the impact on the CPR portion of our clearance process.
And only on the CPR portion.
That's correct.
Councilmember Henderson?
Thank you, Mr. Chairman. As you were sort of going through the process, I remember back when I got the job offer from DCPS when I was just working in central office, but I also had to go get fingerprinted, get a background check. And when I saw, I have to get a TB test, what in the world? But yeah, you, as the applicant, you are responsible for accomplishing all these tasks. And when you take time, it takes time. Question though for you. I have to imagine DCPS does not treat classroom teachers, OST volunteers, or OST staff on the same level of priority in terms of processing. Yes?
In terms of our processing of clearances?
Yeah.
Councilmember, actually, can I make one clarification?
Okay.
Because you referenced the TB test submission. I do want to share that in the past 2 years, we have updated that TB screening requirement. Not everybody has to. We follow the guidance in DC Health that basically gave us a good practice of asking people questions about where they've traveled and for what length of time, and individuals who are flagged as being at risk of TB, along with some other information, only those individuals are asked to get a TB test. So that screen is required. It's answering the equivalent of a few yes/no questions.
Oh, that's great.
Then, yeah, so I do want to clarify that because I too needed to get a test, but we have changed it since then. The goal of streamlining. So all that being said, so your question for DCPS is whether or not we treat contractors, employees, candidates, and contractors the same in our clearance processes.
Right. So when you send it over to CFSA, and Director Matthews mentioned that occasionally, and it may not come from you all, but he says occasionally someone will call and say, hey, we need to expedite said person. I'm just curious in terms of the hierarchy here. Are we putting classroom teachers ahead of everyone else? And that's why we're hearing more from out of school time and volunteers in terms of the length of time.
So for DCPS's portion of the process, we do not hold back anything or push forward anything faster or slower because of the role. The beauty of the system we have is right now is if anybody goes in the clearance application, no matter who you are, for that CPR portion, your information goes straight into their system. And so there's no prioritizing DCPS side. We push everybody forward, and we do not make a distinction. Our application doesn't make any distinction between role type.
Okay. The current law requires DCPS to call the former employers to ask in terms of any allegations of sexual abuse, et cetera. Do you all perform that check?
Our clearance application does include a very robust set of questions around criminal background and attestation, where we list a number of offenses, and each applicant is required to attest as to whether or not they've been arrested or convicted of the range of offenses,
right?
In addition to the range of checks that we've talked about, the fingerprinting, the sex offender registry, and the like.
Okay, but the law is two-step. It requires the self-attestation, but it also requires the LEA leader to call to check. The proposed legislation removes that, but we heard testimony earlier that they wanted to keep that. And so it's a little disheartening to hear that DCPS is not calling at all.
We do conduct a rigorous reference check process in alignment with our hiring practices that we and our suitability processes that we believe meets the intent of the act. In order to check that many years of employment history for hundreds of new hires annually, we would just need to significantly increase our staffing team significantly. And so we are aligned. We are, think the 7-year look back is appropriate and it's reasonable, and think it's
right. But if we put something in the law and then y'all just ignore it, then what's the point? I'm not trying to be argumentative. I really am just sort of trying to figure out here, if we put this back in terms of calling to check, are you actually going to call and check? Or just decide that your own process requires that you don't follow what the law says?
Yeah, I understand the question, and I appreciate it. What I would share is we have been working to implement the most critical aspects of the law to mitigate risk. Again, the CPR check was one of many provisions, and it actually, this law expanded throughout many teams in all of our schools. And so while I could certainly understand your question, please know that we've been working extremely hard to implement a very rigorous suitability screening and reference check process, so everybody in our schools are keeping safety paramount for our students.
Okay. I'll just say this. I think the reason for the introduction of the 2018 law was because of gaps in terms of background checks. And so I'm not sure that this necessarily gives anyone, well, I'm just going to leave it. I'm going to leave that there. And we'll talk to DCPS off that one offline. Director Matthews, let's talk about the CPR for a minute here. You were doing an exchange with Chairman Mendelson around what do you provide to the employer when they do the check? You say, yes, someone is on the list or not. Do you say whether it was inconclusive or substantiated?
No, we don't provide that information.
And you don't share whether it was abuse or neglect?
No.
You just say, they're there.
Absolutely.
Good luck to you.
Yes, because I mean, that's confidential information. So we're bound by the confidentiality laws.
Okay, when did we start the CPR?
Oh, that's a good question.
2004? 2002.
Okay. Was that retro?
What was that, 2004?
2002.
Was that retro? Meaning anyone who had claims or of abuse or neglect prior to 2002, were they uploaded into the system?
I don't think we have enough information to know that. I would beg to say that we wouldn't necessarily have it to be able to enter into the system. I think I hear what you're saying. I think based on even how we, bring online new systems now, it's from the start of the time the system comes online versus looking back.
Right. What I'm trying to get at is the questions around expungement. So someone who had interaction to end up on this list from 2002 forward is still getting hit for that. But anyone prior to 2002 who might have had a situation that was substantiated is no longer there.
That's correct. That's correct.
Okay. In the testimony earlier, someone brought up in terms of like the proposed years after the date that a report was entered. Can you speak a little to why you all believe that 3 years, or is it appropriate time for certain things, 5 years for appropriate time for others, as opposed to a longer period of time?
So I can speak to that a little bit. As we had indicated earlier, that will be shared. A lot of this came from recommendations from the task force, which was very robust. And I believe it was about a 3-year process that we conducted some research from other jurisdictions, looking at our demographics and looking at the tiered process. If going over the tiers, obviously the last tier indicates kind of the most concerning reports of abuse and child maltreatment. And so that's why we wanted to ensure that we had a tier that was that continued to have people on for life.
Got it. Okay. I think Councilmember Joe might have asked you this a little bit, but there was a suggestion that this be a petition process and not an automatic expungement.
Yeah, that was actually suggested through the Children's Law Center in terms, I think they mentioned as a petition-based process. And again, I mean, when we're looking at our current policies and our new work tool around race and equity, if an individual meets conditions, I'm not sure why we would continue to subject them to another process to where, oh, I have another hurdle I have to get over. If they met conditions, then expungements would be expungement and it should not be questioned.
Okay. If someone were on the register for something that was a substantiated claim of abuse, would it pop somewhere else in the background check process?
Maybe criminal if there was an investigation by MPD, but in terms of specifically the child welfare aspect, it would definitely show on our register. But if there was a conviction or prosecution, it would show up on the criminal side.
Okay, so, but let's unpack that a little bit. As CFSA is a mandated reporter, if you all received a report of abuse that you felt, well, not that you felt, you received a report of abuse that needed to be reported to MPD, you would do that, yes?
Yes, we do that. That's probably every day. We do that every day, yes.
Okay, but the MPD background check or the police background check would only show conviction, not investigation?
Say that, ask that again. I want to make sure I understand, council member.
So, and I know that I'm asking you this as opposed to MPD, but I'm trying to get at this question around overlap, right? So there was a suggestion that our belief that there is some significant overlap, right? If there is something, a serious abuse allegation, someone will make the claim that it will not always show up on an MPD or other background check, and that the CPR is the only place that it would be. But I'm trying to show that when there is a serious whatever of criminal activity, as a mandated reporter, CFSA would have to make that report to MPD. MPD then would be required to investigate. And if they move it on to criminal charges, that would show. Yes?
That's correct, yes.
Okay. What wouldn't show is if MPD investigated, but did not believe that criminal charges were warranted.
That's correct.
Okay, so it wouldn't show investigation, but it would say it was someone investigated, someone believed that there was something wrong here and charges were brought.
Correct.
Okay. I finally wanted to ask about, and I'll ask this to both DCPS and CFSA, and CFSA, obviously, I mean, I know you guys have a sort of unique relationship here, but you're our child welfare agency. We've heard a number of suggestions and desires from, folks in the community who would like to see violence interrupters more engaged and involved in our schools. In fact, I think it might be a nice trade-off to, as we reduce the number of SROs, having violence interrupters who are now part of the program in schools in terms of restorative justice and otherwise. However, we know that some of the individuals who are involved in those situations, have backgrounds that wouldn't necessarily clear them of a background check to work in a school. And so how would you all suggest we navigate this particular issue?
Councilmember Henderson, I think that is a great question. And the best example I can use is that CFSA hires parents who have had their kids removed and successfully reunified. With even having a finding on the register, I have the power to actually waive that. And the reason why that's important is because they actually have experience with navigating our system that would be beneficial to a parent who may have recently had their kids removed. And we found a lot of success when you pair both of them together, even though we have, I believe, the greatest social work workforce in the country. When you have someone who can relate to you, who've been in your shoes, who've walked your walk, they can also be probably more successful. So I think the same about violence interrupters. If they have a background, which they probably do, I think the district has to find a way to waive that issue to ensure that if we find it to be a benefit to the school district and to schools, we should do it.
Ms. Gaskins, do you want to weigh in there?
Yes, thank you. I think Director Matthews said everything well, and I echo his sentiments.
Okay. I think maybe, yeah. I love that you guys were like, yes, we would support it. Y'all come back to us about a proposal. I know this is a question during question and answer, so you might not have necessarily been prepared for that. But Chairman Mendelson, I don't know if we have enough time to sort of work through that, but I definitely have interest there, especially as we have seen, even just in the last 2 weeks, the amount of teenagers in particular who have been victims of gun violence in our schools, or excuse me, in our communities, who attend our schools. And I think this is a worthwhile endeavor that I think we can all put our heads together to get creative around in terms of helping provide these supports to these school communities. But I don't have any other questions. Thank you all for your testimony and for being here today, and for your work engaging with my office prior to this.
Thank you, Councilmember Henderson. If you have some legislative thoughts, feel free to share them. We're looking to move forward with this legislation. If I remember correctly, I think we're thinking of the December 6th meeting. Yes, because the record's open until November 16th. My staff, you can reach out to them.
Yeah, I think we might need to engage Councilmember Allen, maybe.
Okay.
Because of the one's office, yeah.
I have 2 more questions. Ms. Gaskins, does DCPS exclude candidates from consideration if they're listed on the CPR registry?
Yes, we do not hire individuals who are flagged as not cleared from the CPR registry.
So somebody's on the registry from 10 years ago for a minor instance of neglect. If you're on the registry, if it's substantiated, I can't say it's minor, but we're not talking about the same as abuse. You don't know any of that. but the person is disqualified from volunteering or out of school time or teaching.
Yes, thank you for that question. Just to further clarify. So DCPS receives for each application for a CPR check. Once the review is complete, we receive either a cleared or an uncleared denotation for each applicant. And those that are cleared are welcome into our schools. Those who are not cleared, we do not allow them to serve in our schools.
But you did testify that with regard to fingerprints, it could take as much as 60 days because you'll do some investigation if it appears there's a criminal record.
That's exactly right, except for in certain cases, sexual offenses and some other really egregious offenses, yes.
Yeah, so not to pin you down, but to just kind of illustrate, if it turns out I have a criminal record because of a misdemeanor assault from 15 years ago, you might clear me, but you'll investigate first to find out what that criminal offense was.
I'm not the investigations team, so I can't speak to what type of offenses may allow someone to still be deemed fit for duty. But broadly speaking, there could be a felony in the past that upon review using our 7-factor system, the investigations team may deem the person still fit for duty.
Okay, and you said felony and I asked misdemeanor.
Okay, whatever example.
But that's okay. The other question I have to maybe more for Mr. Matthews. So if we go ahead and remove the CPR check altogether, what other types of candidate screenings are in place to catch cases of abuse or neglect that would disqualify an individual? Are there other checks in place that would reveal a candidate's fitness to be in direct contact with children?
I think, Chairman, the way to answer that is that, of course, you will always check the National Sex Offender Registry. I mean, that's a form of abuse, but you want to make sure there's no sex offender being hired. In terms of the criminal piece, which is kind of a little complex to explain a bit, when we talk about allegations of abuse or neglect and whether or not there's a criminal element to it, MPD will do their investigation. They may make an arrest, but there may not be necessarily a conviction or prosecution. So it really depends if it will show up in that way. And I think what people, advocates and all should understand is that both agencies will do their due diligence in doing their investigations. But it should not be that if at the point of the investigation at the end where nothing was found, as if something actually is there. When something is found factually, it will be recorded, whether it's in CFSA's database or MPD's. And if it's there, you'll be able to find it from either. But if you, again, is your question, if we were to eliminate the CPR piece and there are elements of it can be child cruelty or child assault, it would show up on MPD's register.
Yeah, a minute ago you said we could check CF your database or MPD, but if we remove CPR, there's nothing for us to check with you.
No, I'm saying if we remove ours, then I'm saying still, if there's prosecution or conviction on MPD's end, it would show from their register. As you do your local background checks, your fingerprinting and FBI checks, because all of those checks still remain. You're still doing you're doing a fingerprinting, local, national, FBI, and sex offender registry.
Does fingerprint identify arrests without convictions?
Yes, they do.
Councilmember Nadeau, you've reappeared. Do you have any more questions?
I was just trying to get a sense of whether anybody asked a question I had. I'm sorry, I know I'm dragging you out here. I just need to switch back to this memo from my last meeting. I had a question about physical injury. So please, if you don't mind. How does CFSA feel about children's law centers recommended changes regarding the definition of serious physical injury and whether the expungement process should be automatic or require a petition.
On the first, I think we can agree on the definition, expansion of the definition, as I think Tammy mentioned that it was too narrow, so that part we agree.
Okay,
In terms of the petition piece, we do not agree on that.
okay. Thanks. I think that is all I needed. Thank you for allowing me to pop back in as you were trying to wind down, Chairman.
Thank you. Councilmember Henderson, last chance.
I'm good.
Mr. Matthews, you're the only one getting some homework here. You're going to get us to recommendations of the Children's Justice Act Task Force and also the citation to the federal law that created it.
Yes, sir.
And I don't
Oh,
recall.
I'm sorry, we also will provide you the, Councilmember Henderson requested the data from the CPR unit,
Data from the what?
from the Child Protection Registry unit, the data from the past years.
Okay, yes. I'll make sure it comes to both the committee as well as to the council member. And Ms. Gaskins, I think you're getting off without any homework.
Understood.
It was a good day in school for you. I'm going to wind down this hearing. Again, this has been a hearing on Bill 24-989, Educator Background Check Streamlining Amendment Act of 2022. The record in this matter will be open until close of business Wednesday, November 16th. So anyone who wants to supplement testimony or comment and didn't today, you have till 5 p.m. Wednesday, November 16th. I want to thank all of the witnesses, the earlier witnesses, the two who are with us right now. The time is 3:09 p.m. and this hearing is adjourned.